This meeting is made possible through a partnership between Triza Communications, the Creative Economy Working Group, and the Kenya Copyright Board. And it's part of our ongoing work at the Creative Economy Working Group to work with different institutions to develop not only the policy environment for the creative sector, but also to build capacities in different areas of the sector. And of course, we have had other core convenings with Kekobo in the past related to policy and legislation. And I think that it's important that we continue finding ways in which artists can not only create works in a free environment, but also that they are paid for the works that they produce, and that their rights are protected across the value chain. And of course, part of the reason why that doesn't happen is certain gaps, either the gaps are with policy or legislation, or gaps with knowledge. So today we have this tremendous opportunity to learn a little. Of course, the area itself is very expansive, so it's very difficult to finish everything in one sitting. But we will be looking more closely at the sound recording industry, which is basically music, in a more focused manner today, even as we try to open up other sectors in future. And also to say that this is part of we'll have another forum, which will be on distribution, branding, and monetization in the sector. So how do you make the money? How do you distribute your goods and so on? And that will be sometime in November. So I really want to welcome you today to engage with us, and that together we can contribute towards the creation of a thriving, creative sector that is well compensated, that is well protected, and that has the infrastructure that it requires to thrive as a sector. So for today, we have, again, a tremendous opportunity to work with people we have engaged before in terms of these issues, because they are in the practice of creativity, and both of them are lawyers. We have Deborah Wanjugu, who is a member of the Creative Economy Working Group, and who also provides support, especially on matters of policy within the Creative Economy Working Group. And then we have Liz Lenjo, who is an intellectual property rights lawyer, and who has also, both of them actually also build capacity within the sector of copyright. And therefore they are very well informed in this area. So I really want to welcome both of you to this meeting, and I think we will make it interactive, even as you build your ideas and share these ideas with us. In the audience, we have diverse people. Of course, music cuts across all the subsectors of creativity, so it's important for us to start with music, really, because you'll find music in film, in virtually every space, in theater, and so forth and so on. So I would like to start with you, Deborah, really, and to just give us an idea of the industry itself, especially music. How does it look? Who are the players in the creative process of music? And if you could just also give us an idea of what rights exist, for the various players, and then we'll bring in Liz, at the right moment. So if you could just take us through those ideas, that would be very helpful, Deborah.
Thank you, Prof. Thank you for this opportunity to engage in this training. I'd like to request some screen sharing permission so that I can share a small diagram. So to begin the discussion, I think it's important to understand that the copyright system is not something that we as Kenyans or as Africans came up with. It's something that was imported from another jurisdiction, and it had its own settings, its own way of operating in those jurisdictions. And then when it came here, in some ways it works, in some ways it doesn't. So I'd like to use a diagram of the American system to explain who the full players are and how the system operates in America. And then I juxtapose that with the Kenyan scenario, and we see what is working and what isn't. So to begin with, at the top here, you have a composer. A composer is somebody who writes music, whether it is lyrics or notation or comes up with a melody. That's who a composer is. And they, in America, remember this is the American situation, they assign their rights to a publisher who then has connections to various players within the industry who will market and play that music, whether it's on radio, whether it's on a movie, whether it's being sold in a book, notation, sheet music. So that's how the system operates in America. There are several intermediaries, and each intermediary has a purpose. This box, the yellow box on the right, on the left, I beg your pardon, BMI, ASCAP, CESAC, those are the American equivalents of PRISC and CAMP and MCSK. We don't have an equivalent of Harry Fox Agency, but basically that is the role of these people here in the American system. So in the Kenyan system, yes, you have a composer, but the composer also has several other roles that they play. They end up being the performer. They also end up being their own publisher and therefore their own marketer. When we were teaching this course in January, this is the Copyright X course offered by Harvard University. I'm sorry, I just want to stop sharing this screen. When we were teaching this course, we gave the students an assignment to draw that chart from the Kenyan perspective, how it is that they end up operating within the music system. And all the students who are engaged in music said that that chart represents a good example of how music works in Kenya as well, with the exception of the distribution model. So because we are not covering distribution today, we will not talk about it. But what we will mention is that as a result of this institution or this system being imported into the country with competing mindsets and philosophies, you'll find that the law does not fully protect or explain what the copyright surrounding music looks like. So you'll find things like the definition of a composer are not in the Copyright Act, the definition of an arranger, such things, you won't find them in the Act, but it doesn't mean that you're not fully protected. There's a way that the law operates that will allow you to get your protection. So the definition of an author is somebody who creates work. So whether it is a painting or a song or you write a book, a poem, whatever it is, you're an author. If you're the originator of that work, you're an author. So authors are divided into different subsectors or subcategories depending on the work that you're doing. And so because we are focusing on music, I will not stray outside of the musical context. A performer is somebody who vocalizes or plays the music, the composition, whether it's an instrument on an instrument, or if you're a musician, you use your voice to express that music. A performer is also a dancer, but because that doesn't fall within the scope of this training, I'll just pack it aside for now. We also have arrangers. Arrangers are people who take music that exists and then they arrange it in a new way to give it a new life, Hi June, karibu sana, please, thank you for muting. So an arranger is somebody who gives new life to music which exists. And for example, if you want to create a new rendition of Malaika, you will get the services of an arranger who will be able to, get to put that music in a new way that gives it a new sound. So that is the textbook definition of an arranger. A producer is somebody who takes the different elements of a song. So whether it is the lyrics, and then they combine it to the instrumentation, and then they arrange, they do some engineering to bring together the different elements of a song so that they now produce a new sort of IP called a sound recording, which is then now used to be publicized to other people. A publisher is an intermediary who markets and looks for the economic gain of a song. So for the longest time, this is something that did not really exist in Kenya, or it existed in very fragmented ways, which is why the distribution element has been a challenge within the industry. But with the advent of the internet and YouTube and different models like those, the publishing industry is picking up. But Liz will speak more into that. A recording label is the company or an individual who will record your work and hand it to you when it is completed. And then when it comes to owning copyright, each of these people have, based on the roles that they play, they have copyright, that they have rights that they own. So the first person who has rights here is a composer. That composer is the one who owns the full copyright of the work. A producer owns the copyright to the sound recording. So when you go to a studio and you record the work, the producer is the one who's going to own that sound recording. But a composer can also be a producer, especially in the Kenyan scenario. And that is one of the differences between how Kenya operates and other countries operate. An arranger will also, because now they're giving new life to an existing song, they also have copyright within that arrangement that they are creating. So that is a brief overview of the rights that exist and the players within the music industry. I'm hoping I have covered everything, at least at the introductory level. Prof, I hand it back to you. Liz, if you have any reactions, please go ahead.
Thank you, Deborah. Thank you very much for running us through the key players and the complexity of our situation, because sometimes you have one individual virtually doing everything in that process. I would ask that maybe Liz steps in to develop develop line of thinking a little more, and then we'll be coming back to Deborah.
Okay,
Please.
Thank you, Prof, for the opportunity. I'm happy to be here. Allow me to say a special shout out to Miss June Gashui, the fairy godmother of IP. So at one point, I hope she will say something. She's our fairy godmother in this space. So I think now just to add on to what Debbie just captured, I think I will start by just discussing briefly the rights that are usually there in music as we put into perspective these roles. So when we're talking about copyright in music, we have economic rights that you had earlier, Debbie mentioned, and we have moral rights. So with the economic rights, we're talking about the rights that this author, composer, arranger have, and then we'll also fragment now the related rights the producer and the performer have when it comes to this piece of music. So when we talk about the exclusive rights, we're talking about the right to reproduce, make it, basically to reproduce. So the number of copies, they have the ability to control, the ability to, or the right to make available. So you could create a work and put it in your drawer or in your closet and say, I'm not going to let people listen. That is your right. The ability to control derivative works. By derivative works, we mean, earlier Debbie said about how an arranger can rearrange a piece of music, but it cannot be commercialized until the author of the work has given consent, then therefore you can commercialize. So, the law allows you to do what you want to do in your studio, in your house, in your bathroom, or whatever the case may be. You create that derivative works, but the minute you make it available, you need to have had the consent of the owner of the works. Otherwise, it will constitute an infringement. And you'll be in trouble with the law. You would lose the ability to even commercialize or rather make money from it, because as a rearranger or someone who's created new derivative works, you see, you have put some investment, right? So, but in the absence of that permission from the author, you could lose everything. You could lose your investment, and we've seen such situations even with American artists. We've seen such situations, globally. So you want to make sure that you have cleared that right. So basically, sorry, Sharon, could you please mute? So when we're talking about the economic rights, it's about the ability to earn from the works. And then we have, and actually with these rights, they can be transferred where we are talking about work for hire. So in our work for hire would mean, for example, I call Mr. Sigay and I say, hi, Mr. Sigay, please compose a song for my advertisement. I have a product I want to launch, and I pay him the money. Yeah, and now in this instance, I have commissioned him, and I have to put an agreement in place, basically showing that these economic rights will transfer, and that I want to own and have these economic transfers now, economic rights vest with me. So in this instance, there would be a contract, which means he has specifically created a work for me, for my product, and why it's not for that interaction, he was not likely to create that work. So that would be a work for hire instance, and in this instance, those economic rights would then transfer to me. Now with copyright, we talked about now moral rights, which is the right to be attributed as the author. Song written by Mr. Sigay, song written by Debbie, arranged by so and so, composed by, so that is what we call moral rights. Okay, and this is a right that is not transferable under Kenyan law. So which means in the work for hire arrangement, I cannot take that away from you, right? Whatever work that you're creating, you will always be known and remembered as the author, as the creator, as the arranger, as the composer, whatever the case may be, which is something that cannot be taken away. So we have been seeing a lot of contracts in the Kenyan situation where they're trying to take that away from the respectful rights holders, and it is not right. It's actually illegal. So if you ever find yourself in such a situation, that is something you must really fight. And then, it's always important to remember when we're talking about these stakeholders in music, the rights holders, we always like to use the term copyright and related rights. I'm sure you've had that, and Debbie has highlighted that. So just to put things in perspective again, is that in copyright in the music would belong to the author, composer, arranger, as defined by Debbie. And then in instances, the publisher can come in play through an agreement with the author, arranger, author, arranger, and composer, where now these rights have been licensed to them to now market the music, right? And then now in the CMO context, they would also feature at MCSK, Music Copyright Society of Kenya, which represents this bunch of rights, where they also now declare themselves as a publisher. I think one thing that is also important is to always understand this role of the publisher, as earlier stated by Debbie, but there is more to it. You want to understand the kind of work that this publisher is doing. What kind of plan do they have for you? Unfortunately, in our industry, we will have common comments like, oh, it's a standard arrangement. You know, the way you see the contract is the way you must sign it. Please do not be lied to. These are your rights. So a contract is about willing buyer, willing seller. It's about negotiating. So if you cannot negotiate, I don't think that's a deal you want to get into. So it's always important to be aware of that, understand the role, make them be accountable. What kind of marketing plan do they have for you? What kind of strategy do they have for you? Because they have to earn their keep. They have to justify the percentage they'll be asking for in the publisher agreement. And then for the performer, we talked about the singer, the rapper, the background vocalist, the track producer, who is the most misunderstood person, I think, in our industry. And I think it's because of how sort of we do things in studio, and maybe later even June will comment. But you find that when an artist checks into a studio, there are two ways they can approach a particular studio to record a song. In one instance, they will come and say, hey, I have a song, but I just have the lyrics, I have the melody. So I just need someone to transpose it or translate it into an instrument or that gadget in the studio, because it has sort of, replaced sessional musicians. Because before you go and you get a guitarist and sing, and then the guy can figure out the chords and whatnot, and he's able to play this melody for you, and you sing on it, right? So in that instance, when you go into a studio and this person with a fancy gadget in the studio, in that instance, they become a track producer, because now you're singing it out. You probably just don't know how to write sheet music, but you have already composed a melody. So in the absence of that sheet music, does not mean that the melody doesn't exist. And experts are able to now figure out what key, what notes, the whole situation, and they do that. And then in other situations, they show up into a studio and you tell this person in studio and say, the person in studio actually says, I have a track, aka melody, and I think you would be suited to sing or rap on this song. So in this instance, the track already exists, the melody already exists, and the person is able now to just put the lyrics in this context to be able to bring this melody to life. So in this instance, these two parties become co-owners in the copyright, because now there's the beat or melody or component, which is talking about now the composer, right? Who is now the person has composed the melody. And then we have now the author who has checked in with the lyrics. They come together, they have created, so they are co-authors. So in that instance, then you find this particular person is not a tier producer, he is a composer, so he has a stake in that. And then now, if he's also now the person manipulating the gadget in studio, then he also becomes a performer as the track producer. Yeah. So I think that is something that we always seem to confuse versus the traditional definition of a producer, who is now the person who invests in the music and now owns the master rights. All right. Again, in our industry, we find that we're not having conversations about, when we pay this money in studio, what are we paying for? So, the norm has been, you check into a studio, you pay 5,000 or 10,000 shillings. And, the assumption for some artists is that, oh, this 10,000 allows me to own the master rights. Are you sure about that? So unless it's expressly written, because there will be some who might decide, I'm okay with 10,000 bob for you to own the master. But in normal instances, you might find you're just paying for the studio time. Because again, remember, a record label or this studio is a business. So they have electricity bills, that's the sound engineer is being paid for, the rent of the venue, all that investment has to be factored in. So you might want to have that conversation beforehand and telling the studio or the production house that I want to own my master right, and then have it in writing. I think that is always important to have that captured. And again, when it comes to the author, composer, arranger situation where there are many parties, it's always good to have what we call a split sheet where everyone asserts their rights and their share in the music. So then there is no problem when the publisher brings in some money for the music. Thank you, Prof. I think I'm done.
Yeah, thanks. I just want to dig a little more before you move a little bit on the split sheets, huh? And also the key statements when you're doing a contractual arrangement, because it's a business. You know, you are entering into a business arrangement. Are there specific statements that ought to be in a contract so that the business, everybody benefits? There's specific statements?
Okay, so for the split sheet, it tends to be a fairly simple document, but we have seen it evolving. It's not been evolving, especially in my practice. It's been an evolving document. Now, what I have, I've created what you call a split sheet hybrid, because now it captures also other situations that I will talk about. So, but in the introduction of a split sheet, it will cover specifically the author, arranger, composer, right? So you'll be able to say, and composer, you can put / lyrics by Professor Njogu, composer / melody by June Gashumi, arranger, arrangement by, and then you put if there are 1 or 2 people or whoever it was. Now, during this process of creation, it's always important now that also we are having a conversation, because we now understand this document, what its purpose is. So I'm able to say, oh, but Professor, I think what you've done is like 20%. You know, I came up with the melody from scratch and blah, blah, blah. So I think I deserve 50%, because those rights are 100%. So that now it helps the publisher. When the money comes in, 100,000 has come in, it was used on an advertisement. This 100,000, how is it split after, say, 20% of the publisher? So now the remainder, we now sit down and look at the split sheet and we're able to say, okay, June, we had agreed 50% or 20%, Professor, 30%, like that. So, but that after the net from from what the publisher's deductions are, right? So that is always important. We have seen people don't seem to understand that, and then that confusion of what is production in music, and they try to imagine that production has a position or a place in the copyright, in the scheme of copyright rights and even copyright related works per se, right? So that has to be captured in that instance on the split sheet in the preliminary. Then, like for me, what I do to help the clients also just kill several birds with one stone, there will be a performer section where now also the performers are able to declare themselves and say guitar by, track producer, background vocalist, leads, la 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 la, that whole situation, right? And then because we're trying to make things easy for artists in this space, as opposed to ideally having another contract separately with the studio, for me, I have it in that same document. We talk about now the sound recording rights, and then we capture now Kenya shillings, X amount has been paid for co-ownership of the master, for example. So like what we advise most people who have done copyright courses, we're able to tell them, you know what, you can negotiate with this production house or the record label or the producer and say, you know what, me, I only have 50,000. You want 100,000 to own the master. I have 50,000. Can we co-own this right? Right. So then that is put in that section for master rights. So which means both of us will go and declare ourselves at Kenya Association of Music Producers. And I'm saying I have a 50% right in this song. So and so has a 50% right in this song. Yeah. So it has to be very express in that regard. So where master rights are passing, that clause must be very clear. So if you just simply paid money and you got a receipt, it does not suffice, especially with our traditional receipts. It just says amount received, 50,000. You know, so what do you do with that document, right? So that would, in my view, is the best way I have found and most effective way to help capture all these rights.
Yeah, thank you. Another question for me, which I have always thought that those of us who are authors sometimes lose out. It's Are these percentages permanent? Are you able to do a schedule? Because you see, normally in production, you have there is the recovering of costs incurred, at the very beginning of the work. Should we be saying that the 10% or 20% that I get is a permanent percentage, or can we say that after sales of X number, we can then come back and increase that by, say, another 10%, 20%, and we'll be bringing. I know that there is still a lot to discuss, but I thought I should raise this question rather early. Yeah.
Okay, so for the percentages in the author, composer, arranger, those ones tend to be standard because that was the initial contribution, right? Where it could vary now is now with the producer arrangement, right? Because remember, for them, it's about recouping of costs, yeah? Unfortunately, how most producers have positioned themselves is like they own this master recording forever and ever. However, artists always have that right to buy it back, or while the producer is recovering these costs, they should be accounting so that at one point, if they're able to say, you know what, we have already made back our money, we are looking at making at least another 5 or 20% profit before rights revert back to you. So again, we usually see that the reversionary or reversion clause of rights is usually missing in most contracts. I think because some people don't understand, or they just see the one perpetuity in a contract and they're just like, okay, fine, the producer will own this. Then eventually in the course of the business, as you're learning and you're knowing the industry, you realize, what? I really made a blunder, yeah? So we find that for us, unfortunately, it's something that you have to negotiate. In the US, it's provided statutes where there's a provision where at what point or after how many years this right can be revert. Unfortunately, in the US, though, the term can be pretty long. It can be up to 35 years, which is long. I mean, can you imagine you write a song today and then you're waiting for 35 years for your rights to come back? I mean, it's crazy. So the good thing for us is if we are negotiating, and hopefully you have a numbers person, you're able to negotiate and say, you know what, if you're an aggressive producer, in the next 5 years or in the next 7 years, you should have made back your investment and then some. How about the reversion happens in 7 years or something? Or you can also have that conversation about after 2 years or 3 years, we adjust the percentages until such a time you have recovered all your investment and made some profit. It's about negotiating.
Fantastic, fantastic. So that is another skill that we'll need to develop in the industry, negotiation skills, because it's a science. It's not something that you just learn intuitively. It's something that you can actually be taught. Deb, do you want Deb to step back in, or can I pose another question? I've seen a set of questions also in the chat.
It's fine. You can proceed, Prof.
Okay, so I'm very interested. I'm very interested in the whole question of lapsing of of related rights and the timelines for those lapsing. So what actually happens when the rights lapse?
Debbie, I believe that is for you.
Yeah, and it's Deb, do you want to step in?
Yes, my apologies. When the rights lapse, they fall into the public domain, essentially. So they're open for people to use, but remember, related rights are on something like the sound recording. They're not on the song itself. So if the song has copyright for the life of the author plus 50 years, then you still need licenses to manipulate that sort of, to manipulate or work with the lyrics and the melody. But if you want to sample, say, the sound recording of a song which has gone out of copyright, the sound recording by itself, you can take it of that sound recording, but not the lyrics and everything. I don't know whether I've confused people or not.
Yeah, but let me just get back to you on that. So let's say so we have Kenyan composers that composed in the 1940s, 1930s. They passed on in the early 1960s. So it is in the life of the composers, the life of the composer, they have those rights, plus 50 years after they pass on or they pass away. After they have passed away, those rights now get into the public domain, and anybody can is it really owning, or do they really lose? Do they? What about attribution? I mean, isn't it the case that the moral rights are never lost? Is that, if you could just clarify that a little for me?
Yes, thank you, Prof. That's a good question. When it comes to zilizopendwa, as Liz mentioned earlier, moral rights do not have an expiry date. You can never take away from somebody the right that they wrote a song or they composed some lyrics. So you should always give that regardless of the existence of copyright. Even if the work, the guy died in 1962, copyright expired, they still get the right to be called the author of that song, regardless of whether there's copyright or not.
Liz, do you want to step in, and then I'll ask another question?
Yeah, I think Debbie has aptly put it. It's 50 years after death. So after 50 years after death, it falls now into the public domain, and one can use it as they please, and they can do whatever it is. I think earlier Debbie even pointed out about the different, like the sound recording, right, can expire before the lyrics and the composition right, because remember, sound recording right is a right by itself, which expires 50 years, I think, from the date of production and publication made available to the public, something like that. So you might find that it might expire faster than the lyrics and composition, because that one is 50 years after the death of the author. And then, of course, when you have like groups, if you have like bands or groups or whatever the case may be, the 50 years starts counting after the last surviving member of the band has passed on, or the group. Yeah. So you wouldn't say, oh, just because Nani died, it already started counting, and maybe there are 3 other band members who might have another 50 years of their life, and you decided to get rid, So I think it's always important to point that out. I think something else to also be cognizant of, sometimes we imagine that all the zilizopendwas are in the public domain. So it's always important that you pay attention to this author, at what point did they pass on, at what point did they produce the music. And then remember that just because maybe some songs were written before the Copyright Act, and the first act we had was in 1966, it does not mean that they're not protected. The initial Copyright Act stated that all the works that have been created will be treated as though the Copyright Act had existed at the time of creation. So I think that's always important that people understand and are aware of, especially if you're going to use this song in the creation process.
But how do we know? How do we know that a song now is in the public domain for us to all move in like vultures to utilize it? How do we get to know? Who
Research.
keeps the records?
Yeah, I think it's, unfortunately right now we don't have really a record system, but it's about the research, right? And the good thing, we have the internet. So you're able to go online and find what information you might find. If it's not conclusive, if you have journalist friends, you might employ them. This event for journalists could be an area of research and a business opportunity event for them, right? They're able to curate this data and help artists. So as you can see, this brings also a possibility of different revenue streams in the music sphere. So, but it's all about the research and then finding the right people and making sure that at least you have to find at least 2 or 3 people to corroborate your information. Because if you just work on as one source, you know, you might find yourself in trouble, right? And you don't want to find yourself in trouble. You don't want to lose your investment. So the music industry is very investment heavy. So you want to safeguard your investment. So you do that homework and make sure I have information. And we also have Kenya Copyright Board as well. It's also a place you want to go to and find out how can they assist. They have this information. Can they help you? If it's in situations where now it's orphaned works and it's something, it's a piece of music that you really wanted to use and you've done all the work to find this person. You have done call-outs, you've even done a daily advertisement. You see, all this constitutes some effort. So you're able to go to Kekobo and say, but hey, I really want to use this song. It's been 5 or 6 months. These are the efforts I have employed. Could you deem this orphaned works and allow me to use the work? And Kekobo is able to step in, the necessary document will be put in place, and you may proceed on your way and do what you want to do.
I don't know who is going to respond to this, either you or Deb, but there's a question from Collins Mutiso. Is there a digital way of copywriting songs? I hope that the question is clear. If not, we'll ask Collins to step in and clarify. And then from Karen Wanjau, are there any remedies for breach of moral rights or failure to attribute after the death of the copyright owner to their heirs? So because you have said that moral rights do not expire, so what remedies exist to kind of protect them if they are breached? I don't know how you want to respond to those two.
Maybe would you like me to say first or you comment first?
Yeah, you can answer and then I'll pick it up where you leave off. Okay,
so I'll start with the first question. I'd like to imagine that his question is there a digital way to register your copyright when they meant that? So Kekobo has a very easy to use system. I forget the URL, but you're able to get online and create an account and register. So I'll remember the URL and type it here. So basically you're able to declare what category of works you're trying to protect. And then, tick the boxes. So if it's music, you're able to put in the relevant information. If it's a sound recording, you have a separate box to tick the whole situation. You're able to fill in all those details, and even have your certificate 2 to 3 working days. Sometimes you can even have it within a day. If you did it in the morning, by 4 o'clock, you have your certificate, which is pretty impressive. So we've come a long way with that, and we really congratulate Kekobo for that ability. Yeah, there it is, nrr.copyright.go.ke. So it's always important to do that. And this registration process, it is not mandatory by law, but it is prudent. Yeah. So because people have had, copyright is inherent, it's automatic, we're like, you know what? It's prudent because remember, copyright protects the expression of ideas, right? So which means how Professor Njogu will express, how Debbie will express, and how I will express, totally different, right? So you register that to show that creativity and to assert yourself in the expression that you have created. Yeah. And also so that it protects you in case you had a business partner who decided to run away and do something, you have at least protected yourself and you're able to say, you know what, in my instance, I'm the one who came to the table with this expression, with this work, and I had called so and so because they have the financial input, they have the contacts and whatnot. So that registration becomes important. However, it is not, so it doesn't say it is not challengeable, right? Because again, as a creator, you want to always protect yourself because unfortunately, the truth is people are always greedy, can be funny and fishy, yeah? So which means even those emails that you put together are always important. Don't have conversations simply on phone calls. You can never be able to prove a phone call happened on 19th June 2024. you won't be able to do that. So have an email. After that conversation, an email, hi Debbie, how are you? It was nice to have that meeting. Remember I shared with you and we did and we agreed. Have that in writing. So that now if Debbie decided to be clever and go and register, you're able to fight that registration and say, but here is proof that we were actually co-authors, or it was actually my work, or whatever the case may be, right? But that registration is always prudent. When it comes to remedies of our moral rights, unfortunately in Kenya, we don't have much precedent, but of course the outcome in court will vary. For active moral rights, like the person is alive today, right? You see, if I'm alive today and my moral rights have not been respected, it's actually affecting my earnings, right? So in that real time, when I am, my only cost would actually is likely to go to court, but I may also first seek Kekobo's assistance. So if I'm going to look for alternative dispute resolution, I will seek Kekobo's assistance, maybe ask them for a legal opinion, so that when I'm going to the negotiating table, I am like, you know what, I even have a legal opinion from the copyright authority that says the following: let's make this thing go away. Because if I use this in a court of law, you're going to pay me even more. I will cry even for legal representation fees, to pay my lawyers and all that stuff, right? So we always advise at least alternative dispute resolution, because the industry is always moving at a fast pace. Litigation takes a while, right? So that, in my view, would be like one of the first causes of exploitation. And then secondly, now, should you have to go to court, again, now you have been making those kind of arguments and you're saying, Your Honor, I am losing out because had they credited me, maybe these people would have known something may have happened in the industry or with your work that made you lose out on an opportunity and things like that. And you're able to justify. And of course, if you're alive, you'll make more money for when your right has not been respected and has been infringed upon. However, for a deceased person, that may depend on the scenario and the kind of arguments that you make to justify also how much you're asking for. Because most of the time now it's about compensation, and in the compensation that's about deterring, and the court will be looking at the circumstances and the strength of that claim. So of course it might be less strong when the artist had already passed on. So maybe they're just told, you know what, go back and say originally composed by, originally arranged by. It will depend, because that again will also be at the discretion of the court. Debbie?
Thanks, Liz. Yeah, just to add on to that, moral rights are not transferable. So when a person dies and then the copyright expires, and then somebody infringes or not infringes, but uses their work without attribution, the most you can do at that point is just point out the work was originally done by somebody, and it is good manners, for lack of a better word, to express that this is not an original idea, it was borrowed from somebody else. There's nothing wrong with just attributing the originator of that work even after their moral rights have expired. So, after the person has passed on. There's no harm in doing that. So I just thought it's important to bring that out. Then there was a question on ban convention, but on works that have been infringed in another jurisdiction. Should I continue with that, Prof, or should I let you come in first?
There is a question by Wino, whether artists in Kenya who register with Kekobo are protected globally from plagiarism or sampling or any breach of their works, and whether that is so is Kekobo itself able to operate outside of our borders? So I think that you can address that question. But I also think that it might be useful to make a comment about two things. One, a statement related to fair use of music, because I mean we are trying to encourage our people to earn money from their talent. But is there a way in which that money might not be earned because the work has been used in a fair use. So that's one. And also, again, both of you, you can also reflect a little more about if we are saying that there are sometimes breaches of moral rights. I mean, and we know especially because of our communities are not illiterate. Um, is there a mandate at Kekobo, for example, to continue insisting on the enforcement of these moral rights, even when they are not transferable? That actually what you said, tabia nzuri, ni tabia mbaya, to claim that something is yours when actually it's not yours. But is there a way of documenting who actually owned that, even as it's slipping into the public domain? And whether that would also be a Kekobo task in their research department.
Thanks, Prof. Let me start with that last one. It's difficult because you see, copyright exists upon creation. So the right to share that work with the public is solely on the author. If the author passes on without having shared that work, and then maybe the niece finds it 3 years after their death, and then they start to play around with it, and then 53 years later, they drop some work on it. The fact that the original person who died, that first author, the fact that they hadn't publicized that they owned that work makes it a bit tricky. Because if you own that voluntary expression means that there are sometimes you will fail to know who the original author is. And it's actually a big issue, not just in Kenya, but globally, that works are created and you're not entirely sure when it was created or who the correct rights holder is. So you find that you can't use it until after a particular point when you're sure of its status, or you just can't use it at all. So that's something that there's no fixed way of dealing with it. It's just, as Lee said, lots of research and due diligence on the part of anyone who wants to build upon existing works. Regarding infringements in another territory, yes, you can sue, but it's a bit, I'm not sure how to bring it out very quickly and simply. So there's this convention called the Berne Convention. It's an international convention that deals with the basic components of copyright law that every act in a country should have. And copyright is very territorial. So that means that the laws of Kenya are very different from the laws of Tanzania, the laws of South Africa, the laws of Germany or the EU, the laws of Canada, the laws of China. They're very different. So you need to make sure that if your work is going to another country, you comply with the requirements of that country regarding registration of copyright. Because if I can use America as an example, for you to get damages or for you to be paid for an infringement, you need to have registered your work with the Copyright Office there before the infringement took place, not after. So if you know that your work is going to America, you just need to start registering it immediately, so that in the event of any sort of infringement, you're able to recoup any investments or what are they called? Damages out of that infringement. And then it's very important to ensure that the country is registered or is a signatory to the Bern Convention, because the Bern Convention has the principle of reciprocity. So if, say, Kenya is a signatory, which it is, and South Africa is a signatory, then it means the laws apply both ways. South Africa will protect me and I will protect South African artists. But if the country is not part of the Bern Convention, now that complicates matters significantly. You need to ensure that there was a bilateral agreement, and enforcing that will be very difficult. So most countries have, they've signed the Bern Convention. I think it's only 2 or 3 that haven't, but most countries in the world have signed the Bern Convention. So that should be fairly safe. But you still need to hire legal expertise from that side to help you get the remedies that you need. Liz?
I think in that regard, I won't add much. But something that I think is important to also be aware of is when we are talking about infringement in the digital space, the good thing is we have the takedown notices that are now almost a global practice, right? So what basically happens is that you have the ability to raise a copyright concern or strike and basically state that my work has been used, this work is not legitimately online or being commercialized or being made available, right? Depending on the channel as well, some channels might want to see some proof of authorship or ownership and whatever the case may be. So it's always important that you have that registration, you have, you know, other proof as well to show that it's been in your channel. Maybe you created it in 2003, and 10 years later, here 2013, someone has tried to upload it and try to claim that it is theirs, right? So it's about the takedown notices. However, you have to be also prudent with how you use the takedown notices. They have to be used in a truthful manner, because like for us in our Copyright Act, we have sanctions for people who try to misuse them, because you cannot just use them willy-nilly or as you decide because you want to punish someone. So unfortunately, in our industry as well, we've been seeing that in the last 2 or 3 years. You know, if you are a fan of Kenyan music and you go online, I think that is some of the situations you will see and instances. So it's always important that they're used in a reasonable fashion and prudently. And, you know, in the event that it's not been used in a good way or in bad faith, you can always make that person be accountable in a court of law or with Kekobo regarding how they have used it. Yeah, I think that's what I would like to add.
Yeah, thanks a lot, Deb. Thanks a lot, Liz, for these very clear, responses. I think that we can now move on to issues of cover and sampling. As you cover that question, just a quick response: is Kekobo always available? I mean, if I have a problem with my creation, is Kekobo always available for me to go and seek support?
In my interactions with Kekobo, I think I am very happy to see how they work. The kind of support I have needed, I have always gotten. When I have clients as well, I tell them this is where you need to go, and they do their very best to ensure that they assist. So I find that a very commending efforts on their part. They even have taken it on themselves, even though it's not under the act, where they even help artists to resolve some of the disputes, especially where clients do not have the financial budgets. They give that provision and they say, you know what, since you're here and there's a situation, we can help you. As long as both parties are willing, we will help you find middle ground, which I think is commendable.
On cover?
All right. So we'll comment on cover, and then we have to go back on the issue of fair use, which we forgot to answer.
So that you guys can start.
Sorry, someone needs to mute themselves. All right. So I think Prof, hopefully you'll remind us about fair use. and then we capture that. So when it comes to sampling and covers, the basic principle behind intellectual property law, behind copyright law, it's about recognizing the author or the creator or the inventor, and being cognizant of that fact. You have to have permission. For you to do anything with this work, you need to seek the permission of the author, unless they have reverted into the public domain. So the common principle is that if it's not yours, you must clear it, all right? I know that sometimes we are really confused with some of these international practices and doctrines like in the US, but however, the common principle is that if it's not yours, you must clear it. Because at the end of the day, if I hear a certain song or I hear a certain melody, as long as I can point out and say, that is Professor, that is Leswanyika, that is Sijui who, as long as that can happen, it means that you must clear. But of course, we've seen crazy thoughts where like Kanye tried to claim copyright, I think, of a G sharp or something like that. Of course, that's not going to happen. Yeah, because that is a basic note. It's a raw material in the music space, right? But where the melody is distinct, where I am going to create a piece of work from an original work. We talked about derivative works. We talked about the author having the sole discretion to authorize derivative works. In the absence of that permission, it is infringement, right? So you must seek permission, whether it's a cover, whether it's, the law doesn't prevent you from doing it in your bathroom or whatever it is. But the minute you make it available to the public and you try and commercialize it, then you're going to be in trouble, right? You can do it in your private space, you're fine. But the minute you commercialize, then you're going to be in trouble. I think at this point, then it becomes an easy transition now to talk even about now fair use, right? So now in instances, I teach music, for example, right? And I say, oh, I like this song. As I'm teaching, I don't know, chord progression or whatever the case may be, we can use a song and build it in class, destroy it, or do what those things are doing. That's education. For education purposes, it's fair use. It is a limitation. It's an exception to copyright. So which means in this instance, the author can't claim infringement because it is being fairly used to educate people to understand music, to learn what it is that they need to learn. That becomes a good example. Again, just because it is a fair use, that it doesn't mean that you have the authority to now put it online. Yeah, because now that sort of changes. I think the one thing that we are not realizing is how the digital space has changed the dynamics of copyright. Okay, so in the classroom, it is fine, but the minute you're going to put it out there, make it available to the public, and all manner of, you might open a whole kettle of fish, then it is prudent that you alert the author and say, you know what, I did a class, I would like to make this class available online. Are you okay with it? If you are, please sign here, because this is what we are trying to do, right? And they have the right to also object, because it might interfere with some of their rights. It might interfere with their ability to earn from the song. It might open them up to some unfair criticism that will affect their earnings. So you have to be thinking about such things. So again, when it comes to exceptions of copyright, they are not 100% foolproof. It's also about looking at the rights of the author and other rights holders and seeing whether it balances. So if you end up crossing a line, then you'll be in trouble. Again, if we're talking about news or reviews of songs as well, that becomes fair use. So if you have like a program, it becomes important. It becomes an exception, but again, it will be about the how. So sometimes your review may be less of a review and more of an exploitation. So it's always important that we understand. Again, the issue of parody. I think our industry, we have seen, hey, parody has become a cash cow. So I think I'm looking forward to the day we have very robust discussions and cases around, especially parody in music, because when we look at how we consume music, again, we have seen instances where these parody artists are cashing in more than the author. Is that fair? Like, that is I've been very keen to have that conversation one day in the future. But in my view, the minute it starts interfering with the earnings, I think it's only fair. In my view, it's a derivative works, to be honest. And even just looking at how we consume music as Kenyans. When Kajairo started, I think most of his parodies were popular on Skiza tunes during that time. So, so again, it's all about that balance. So if you're not, if it's not tallying, if it's not a fair use per se, then it will likely be to your detriment as the user, and you're likely to be answerable. Debbie?
Yeah. Actually, before we bring in Debbie, I really would like to facilitate a conversation around parody in music, and just to look at it. So I will definitely be calling such a meeting, going forward, because it also puzzles me in terms of how much gets earned through parody, and whether the original composer does not deserve a percentage, even if it's just a small percentage of the earnings. And again, before Deb steps in, maybe both of you can handle this, because we now have the Traditional Knowledge and Cultural Expressions Act, and some of our traditional music is really making inroads into contemporary music, as it were. So if I took say a Samburu song and I rendered it rather strongly and became extremely popular, does the Samburu community deserve anything as the original composers, or is this still part of the public utility? And if does it matter that I'm Kenyan? Supposing it's a Briton that has taken it. So if you could if maybe you can deal with that, both of you, and then just before we move on to something else.
Thank you. Debbie, would you like to say something, or I proceed?
Yes, policy is my strong point. So the TK Act is something that, wow, you had to do this, Prof.
You bet.
Okay, so that is actually an issue that we raised at the point of discussing this, the TK bill. When it was still a bill, we were discussing it, and we raised such a concern that with the definition of community, if you limit it to it being applied to an ethnic community, then what does that mean for the Kenyan community? So using that example that you've brought out on the Samburu song, fine, I am not Samburu. Now, should I be punished for not being Samburu but being Kenyan? And yet we know that without that contribution they have to the Kenyan society, I wouldn't be fully where I am. There's something that would lack. There's a sweetness that, because for me, because jewelry is my area, the beads and the style of their jewelry and how they play with leather when it comes to making leather bags, it does something for that area, the crafts area. So if you're telling me that I have to pay every time I go to Masai Market and buy Samburu beads and incorporate them into my jewelry, then I mean, what are you doing to the Kenyan society? And then, for example, now for Sauti Sol, they have this Lipala dance, which is a change of the Isikuti dance. So should Sauti Sol pay royalties because not every one of them comes from the Luhya community? Those are some of the challenges we have with the TK Act. When it comes to the application in the Kenyan system, applying it to fellow Kenyans, it brings out now those questions of the negative elements of ethnicity, and it also puts things like Sheng in a precarious position, and yet it's a very important part of integrating urban cosmopolitan culture. When it comes to foreigners, the reason the TK Act exists is because of that element of, you remember how Maasai is the biggest brand that has ever been, and how everybody milked from it apart from the Maasai themselves. So the point is, if the problem is foreigners coming to misappropriate our culture, shouldn't that be addressed at the level of policy and international relations? Why drag innocent Kenyans into the whole conversation? So that is my response to the TK Act. I think Liz has answered the question on fair use quite well.
Thank you. We will definitely have some time in future, a moment to discuss the regulations of the Traditional Knowledge and Cultural Expressions Act. I think it's a very important activity. And I said, remember at the beginning, I said that music cuts across virtually all the subsectors of the creative industries. And that's why beginning with music today was very, very strategic. Maybe we should move now a little more into the exploitation of the digital space and revenue share. And your own reflections about that as we try to, and I will be bringing back, I will be asking June to step in to share with us any general reflections that she has had so far. Liz, do you want to get into that space of revenue share?
Okay. So I think my thoughts and comments on issues of revenue share is, I think first things first, during the recording process, the different parties who are usually involved don't seem to be having this conversation, right? So you find that we check into studio, we do a collaboration, and then we've not even decided, is it going to be on Professor's album? Is it going to be on Professor's YouTube channel? You know, those simple conversations, because if they're not had, again, they bring trouble. There'll always be now issues, right? Again, issues of revenue share, because again, when we're talking about the digital distribution, you'll find that there have been arguments that this is more of a rev share than royalties, right? So if we're having a revenue share conversation, again, in this instance, it has to be a very fair conversation, right? It means that all the people involved in this song have to be factored in, because at the end of the day, you know, in some instances, why should one party gain more than the other? Yet there was a collective process happening when we were putting this song together. So which means, me, in my view, I would say that even now, as we're having these conversations, that somehow we can factor in performers in this regard and say, you know what, because you are here, whatever we make, you get 5% or whatever it is. But there's some sort of remuneration, because that is money that is directly going to be controlled by one of the parties receiving this money. The CMOs have nothing to do with this. So I think in that instance, then it's always important that when we are creating music, we have that conversation. And then we also appoint a lead person, right? So that then we're able to address the issue of duplicity of effort, because if we duplicate again, we're going to lose out on the potential to earn, right? So if I have it on my YouTube, you have it on your YouTube, the eyeballs are split, right? And yet if we consolidate it, we're probably going to make more money on YouTube. We're able to make more money on Spotify and all these other digital platforms. We're able to do that. But it means that we have to actually organize ourselves as a team and agree what is the business strategy for this song and how are we going to distribute it, because it's now up to us to decide. So it has to be a prudent decision. Those would be my thoughts. And then, of course, when it comes to now contracts, if you're going to have a third party involved, it's always important to interrogate, what does this distribution deal mean for me and the fellow rights holders, right? Because you'll find that sometimes, you know, someone is easily duped, for lack of a better word, to sign a contract because they've been promised heaven and earth. And then later on, they realize that, it's not even what they thought they had signed, right? And now it's to the detriment of all these other rights holders. So again, it's always important to interrogate that contract, interrogate what that means to you, being aware of territoriality, that, you know, if you're going to sign with another party, I can assign my rights for this particular region and assign another rights, my rights in another region to another party, such that my eggs are not all in one basket. Yeah, that I am able to, I can even gauge how am I doing in West Africa versus East Africa versus South Africa, because I also have different people. Then you're able to see, oh, you know, if South Africa is my best, is my cash cow, maybe my next album or 2-3 songs in my album will have some element of what South Africans seem to love a lot, or something like that, or do a collaboration with a South African artist, or whatever the case may be. But I think when it comes to distribution, it's something that artists need to be very careful about, very deliberate about. Before you sign that deal, please talk to an IP lawyer, even have conversations with your fellow artists. Find out the street credit of this particular entity you're about to get into business with. Because even before you engage a lawyer, you'll be able to tell if it's a good deal or a bad deal, because you've talked to at least 3 of your 4 colleagues, and they're able to tell you, this is what I've had. Based on that, you do further research like that. Because I think that is something that we're also not embracing as artists. Like, we just want to take things on face value and trust that people will do great for us and they will be fair, but that's not the situation. That's not how we work. Yeah, I think those are my comments.
Yeah, we work a lot from the heart, and we trust a lot, because as artists, we are people centered. I mean, so the money sometimes is an afterthought, and I think that maybe one of the things we need to do is to amplify the role of the intellectual property lawyers in our work. I mean, in conveyancing and so on, the lawyers appear to be really popular, but we are yet to really embrace our IP lawyers, and I think that there is an opportunity as the industry grows to use this. I have seen a comment from Karen Wanjau that she has come across record label agreements that denied publishing of works on any platform by the artists themselves, but solely by the record label, and this may tend to reduce earnings. Isn't that a little bit radical? What is the reasoning behind that? Maybe that's something that you can comment on. And I also want to recognize that Dr. Lagat has made a comment related to our traditional knowledge and culture expressions regulations, and I'm happy that he has indicated that there is conversation in government to look at those, and the comment made by Deborah has been noted and would be taken into account going forward. So thanks a lot, Dr. Lagat, for that comment. And so, Liz and Deb, what's your comment about this tendency?
Okay, I think I can go first. Being that I see these contracts almost on a day-to-day basis. First things first, it depends on the nature of the record label agreement. Yeah, so we've had about 360 deals. 360 deals basically mean that the record label will record, will publish, and will manage the artist. So they will handle all these 3, right? So in such an instance, then of course, that music will then be published on either the author's channel with the control of the label, or the label's channel, because of the issue of recouping the investment. So unless you negotiate another deal outside a 360 deal, then you're able to have those negotiations. Again, also remember, it's about negotiating power, because once a record label has formed, it's a company, it's about money, it's about profit, it's business, right? So these proposals have to make sense even for them to see if, and assess whether the investment is going to be worthwhile. So of course, you might find that an artist who's been there for a longer period, has had hits and hits and hits, is going to have definitely better negotiating power than someone who's starting out, right? So now then the art would be, if I'm starting out as an artist, how do I make sure that the contract is drafted in a way that I understand, they understand, we are on the same page? Again, hopefully, we move away from more very legalese kind of contracts, such that now as an artist, I'm able to say, but clause 3 says X, Y, and Z. there's less of thou shalt, you know, and it just simply says this is what it provides for. But at the end of the day, it's on a case by case basis. It's about the artist's career, at what level they are at, because at the end of the day, some of it is justified, especially if you're a newbie. If you're a newbie artist, it means the label is also investing in your image, because now they need to make you known, right? And they want to be in a position to be able to control, to be able to market and whatnot. So, you know, if that is not your forte, let the pros do it. But as you negotiate your contract, if you have a plan as an artist, then you're able to see yourself how you roll out after 5 years, once their contract has lapsed, like you have a plan, right? So again, in this instance, I would say, please have a team. Don't try to be what a phrase we call peke yako productions. You want to do everything. You want to be the artist. You want to be the lawyer. You want to be the marketer. You can't do everything. You know, some eggs will fall. So have a team to help you make prudent and wise decisions.
Yes, the Pekeyako production sometimes is problematic. Yeah, Deb?
Thanks, Prof. Mine is more of a general observation on the difference between how Kenya operates and other jurisdictions. You've seen how record labels, they try to operate but don't have the same success as they do in other places. And it's really boils or points back to what I brought up in the beginning, that this is a system that comes from outside of Kenya. And so all we are doing is using something that was brought here. We haven't fully embraced it with its idiosyncrasies within the Kenyan system. And one of the idiosyncrasies is that, as opposed to other places where the producer is king, in Kenya, the producer can be treated, or the recording label can be, the recording studio can be treated as a work for hire, where I come to the studio, I record my song, and I walk out with the producer rights. That is a very unique situation that exists in Kenya. I wouldn't say that with authority, that it doesn't exist elsewhere, but I know for Kenya at least, it's very good, and it gives some power to the artists. The recording labels severally come up, they try to negotiate contracts with artists, and then they fold within a very short time. So what happens when they fold? You've had these restrictive contracts that bind the artist, but what happens if a recording label folds and you've not been able to finish your part of the contract by no fault of your own? So is that addressed in the contracts, or is it only one-sided? So I feel like the power, or that potential to just highlight the power of the individual in this whole ecosystem, needs to be probed a little bit more. And we need to find a way of protecting our uniqueness and not necessarily copying and pasting without any form of customization.
There is a question related to the CMOs, which has been raised by Melanie. And I think it's such an important question because we know the music industry in this country is still the most expansive of the subsectors. So it's more visible. It has more people involved and so on. And we know we have had challenges with the CMOs, and they were deregistered by Kekobo. So the question that Melanie is asking is, who is collecting royalties? Are royalties still being collected? And if so, who is collecting? And how will artists be compensated? Can you receive money from an illegal institution that has collected your royalties illegally? If that is the case, Liz, do you want to step in on this one, or is this the time that we bring in Sige?
Professor, I think I've communicated to you on another channel. There are many matters that you are You are asking Liz, which are really Kekombo issues, and I'm here and willing to respond to them.
Yes,
And
please respond. I had not seen your communication, so I was moving. So move in, Edward.
On this matter, what the registration means is that the CMO cannot collect the royalties. But when they went to court and they obtained orders to stop Kekobo from deregistering them, that means that they are free to collect for the duration until the next court hearing. So we will know on November 3rd if they will continue to collect or there'll be another framework. And once that is done, we should be able to advise. So if Melanie owes money for performances, I think I would suggest that she goes ahead and pays until the courts advise otherwise. Okay, so the CMOs are still collecting, in short.
Okay. I know that there were also other questions related to Kekobo's accessibility. Is that something you would like to make a comment on?
Sure. Thank you once again for this opportunity. Kekobo is available, and I think I would advise every listener here to follow our social media handles, and also to visit our website. It has a lot of resources, and we can actually chat with you and resolve your issue from the website. So anytime you wish to walk in and seek legal advice, seek mediation intervention, seek enforcement intervention, we are ready and available on the 5th floor of NHI building. So Karibuni, I think we've been trying to reach out. We have funding challenges, and we really appreciate the opportunities that webinars have given us and the collaboration like this one, so that we can reach out to you. Please feel free to come for those services and learn more. And if you need training as well, we can always, for a group, we can always arrange when you contact us. Asante, Professor.
Thank you, Sige. And also just to say that, of course, at the Creative Economy Working Group, we will always try to support the artists, and where we are able to create opportunity for this level of engagement, we will really try to do that. I've seen a comment on the future of creatives with COVID and so on, whether it's bright or not bright. I think I would be asking my colleagues to make a comment about that. But from where I sit, I think that COVID has opened up opportunities for working differently, and that maybe the future is bright, is rather bright for the creative sector. And I was also this morning talking with Kipra about the opportunities that have been created through devolution. I think we need to do more work in encouraging counties to invest in infrastructure for the creative sector, and also to increase the budgets for the sector. We think that the funding the sector from the exchequer is really important, and the more productions we have, the better it will be for the sector, because you need to have more products from which people can consume. There is quite a bit of work to be done, encouraging Kenyans to consume works created by Kenyans, instead of being obsessed with works created elsewhere. So there is quite a bit of work that needs to go in that direction. I had requested June. I'd say that I would ask June to make any quick reflections from where she sits, and I'll also ask Dr. Lagat to make a comment, because I know that the ministry is building a creative sector framework for development going forward, and I think that that might also be something that Dr. Lagat could make a comment on, because we are now coming to the end of this session for today. Maybe we start with June. Any comments from what we've been discussing with Deborah and Liz from your side?
Thank you, Prof. Good afternoon, everybody. I'm in transit, so you'll excuse me if you hear irate matatus hooting in the background. But I think just first of all, thank you. It's always great to be part of a forum like this. I always say that we should never tire, is I think the Kenyan way of saying it. You should never tire to sort of keep sharing and keep convening to just discuss and share our ideas and keep training ourselves as creatives. I think that's the thing we need to do. Nobody should push us to invest in knowledge. So I want to applaud all of the creatives who are on this call because I think you've taken the time to invest in your craft by learning. To my colleagues, Deb and Liz, I think they've done an amazing job, just sort of like setting context and setting the tone for this and future conversations. I know Tuaweza are planning to have a number of these. I think my take on some of the points that have been discussed, everything from rights holders, the roles, who does what we've inherited. I think Deb has a very interesting take on things that we've inherited in terms of the principles of intellectual property. I mean, Kenya doesn't operate in a vacuum, obviously. So I take her point completely about being able to take the principles and then, harmonize them into, or localize them, I should say, into our laws, into our practice, in a way that we deem fit for our industry. And I think there's something to be said for that, but we do need to first all understand the principles, of who owns what and how intellectual property works. And then the functionality of it can be tailor-made to an extent for Kenya, but understanding that we live in a very global
Did we just lose June?
Hello, can you hear me?
Oh, yes.
Sorry about that, I'm still here. I was just saying that COVID opened up the opportunity for international collaborations more this year than ever before, because you don't necessarily need you to travel, get on a plane and go and meet artist X. But on that point, it means that we do need to still have some sort of harmonized applications of these principles so that we don't have too much of a Kenyanized way of doing things that then does not allow us to continue engaging in some of these collaborations. So I thought that was an interesting point. I really appreciated the TK's discussion as well, and I'm looking forward to maybe a more robust discussion on that. And I know Dr. Lagat will comment on that as well. We're doing some work at KEPSA for the sector board, for the sports, culture and heritage sector board. So I'm very interested to hear how that discussion pans out. I do also think that the discussions around contracts, around being able to understand the business side of things is important. I don't think we can say that enough. At the end of the day, our society is starting to move from a point of view of, music has been there to color our worlds and make our lives more beautiful. But at the end of the day, if this is the calling that you've been given, then it's really imperative that you understand the business side of the creative industry, whether you are a lawyer, a manager, a business person, or the artist. This is your product. It's your intellectual property. It's your property. So nobody needs to be more interested in it than you. The rest of us are literally service providers in your space, in your world. But it's you who decides how it is that you want to handle your business and how profitable you want it to be. Final two comments. Thank you, Professor, for remembering us intellectual property practitioners. It's sometimes a very lonely road. I keep joking about how my office is filled with art from my clients who have not been able to pay fees. You know, it's this CD, this DVD, this sculpture, and I appreciate all of it. At the end of the day, you know, it's a token that I appreciate, but we need to get to the point where, you know, we can also earn a living. You know, the fact that we're passionate or good at the work that we do is not always enough. It's what keeps us here, you know, years and decades later. But I smiled when you said that. So thank you for remembering us. And my final comment is one around just a continued effort, I think, from government as well. And from that point, I mean, I agree with you. We need to have more statistics. I heard you mention Kipra, and I see that Anne Gitonga is on the call as well. She and I have had this discussion about the fact that we do not have statistics. I think that's where a lot of the funding from the exchequer would start from. If the government decision makers do not understand this space, and the reason they don't understand it is that statistics are not available, then that's a failing on our part, because then we cannot effectively lobby for the money that I think this industry and this space really does deserve. So just a continued appeal for us to find a better structured way to get more statistical data that can enable us say, this is how much money this industry is bringing in, and therefore it deserves the support, the infrastructure and the support that, you know, KIPI and Kekobo and the rest of these government registries are doing, but it's not enough. I don't think I am wrong, and I can speak on behalf of Sige and Kekobo to say they could do with more, so that they can have more impact, more sort of offices in different counties so that people can reach them and they can reach a much larger group of people. But I do think the investment in this industry, in this space by government is not where it needs to be. And one of the reasons that is happening is because we don't have sufficient statistics. So those would be my comments for now, Professor. Thank you for the opportunity. And thanks again to everybody who's participated by asking questions and sharing knowledge. Thank you.
Thank you, Joan. Thank you very, very much. And just for you to know that we continue engaging with the Kenya National Bureau of Statistics, and we have proposed to them that we do require a creative sector subcommittee at the National Bureau of Statistics, so that every time they are collecting national data, the subcommittee is able to demand that a question related to the sector is incorporated in their statistics. So we haven't finalized that because the conversations took place during COVID, but we're hoping now with the opening up, it should be possible for us to have that subcommittee at the Kenya National Bureau of Statistics. So I think that we do need the numbers. We need more funding to the Ministry of Culture. We need, and all the agencies that support the industry, we do need that, and that requires a set of advocacy skills to engage with the government so that we keep pushing the budget upwards, and also making demands at the county level to have more investment in the creative sector. So June, thanks a lot, and we will be having another webinar on distribution, branding, monetization in the digital space and beyond the digital space. So I've seen some questions there, and we would like to just ask everybody that has taken part in today's webinar to just mark. I think we're going to do this on November 17th, but we'll, of course, as usual, we'll make the announcement to really talk about distribution, monetization, and branding, and so on. I want to give Dr. Lagat a moment to say, to make some comments, and then we'll just get these to Dr. Lagat, please.
Okay, thank you, Prof, for giving me this opportunity. Good afternoon, everybody. I think these discussions have been very interesting, and I think it is important that we be engaging on some of these issues whereby we get updated on what is happening within the sector. The State Department for Culture and Heritage, together with the Art at Work and the Kenya Bankers Association, has been in discussion for a couple of months now, exploring new business financing models for the creative sector. Towards this end, financial financial sector deepening was commissioned to undertake a research on the state of the creative industries and how they could be financed. They have come up with the specific proposals for the different ministries that deal with the creatives. There are specific recommendations to the State Department for ICT and Innovation, Broadcasting and Telecommunication, Trade and Enterprise Development, but all of them are geared towards facilitating the creative sector to access finances. And one of the key issues that is under consideration is the establishment of a credit guarantee scheme for the creatives, which can be accessed under micro, small, and medium enterprises. And towards this end, we've written to the National Treasury. They are willing to engage. And we've had discussions with the creatives, the members of the Kenya Bankers Association, as well as the National Treasury. And I think there's good progress towards that. We are currently in the process of establishing a multi-sectorial task force that will consider all these proposals with a view to ensuring that at least the first cohort of banks will be on board perhaps by the end of the year, and a new product to finance the creatives will hopefully be established by the end of the year. Of course, it is important that creatives register as business enterprises. It is important that capacity building is done before that happens, and all these institutions involved are currently engaged on that, and we hope that before the end of the month, or before the end of November, at least a big announcement will be made towards that.